Hello and welcome to ProfDale's property video number 51. I'm your host, Dale Whitman. In this video, we're going to cover the law of nuisance. Now, nuisance is actually a tort, and you might be surprised to find it in a series on property. But nuisance cases always involve parcels of real estate, and that's why it's usually covered in the property course rather than in torts. So what is a nuisance anyway? There are actually two kinds of nuisances, public and private. We're mainly going to focus on private nuisances, but the definition is actually the same for both. So what is a nuisance? Well, it involves a property owner who makes a use of his or her property that unreasonably interferes with the use or enjoyment of somebody else's neighboring property. If you want to think of an egregious example, imagine that you have a neighbor who burns rubber tires consistently in the backyard of his or her house. That produces a lot of smoke, dust, and soot that drifts over onto your neighboring property. That would almost certainly be a nuisance. So in a nuisance suit, there are typically two parties. There's the defendant. That's the party who's alleged to be using his or her property in an unreasonable way, such as your neighbor who might be burning rubber tires in his backyard. And the second is the plaintiff, the party who claims to be harmed by that use. What are the remedies that the plaintiff can obtain? Well, classically, there are two remedies. First, damages to compensate the plaintiff for the harm that the defendant's activity has caused, and second, an injunction, a court order to force the defendant to cease. Sometimes the plaintiff will seek both remedies, that is, damages for the past harm that the plaintiff has done, and second, an injunction against the future harm that the defendant's activity might cause. But the injunction is usually the main remedy. The plaintiff wants the activity to stop. Determining whether a nuisance exists is not a mechanistic process. Instead, the courts tend to look at a number of factors, and we're going to list some of the important factors here. The first one is the distance between the plaintiff's and the defendant's properties. Obviously, the closer they are together, the more likely the court is to find a nuisance. Second, what's the character of the neighborhood? Is the activity that the defendant is engaged in typical of the neighborhood? Is this the sort of thing that many other property owners in this area are similarly engaged in? If it is, the court is much less likely to find that there's a nuisance there. Third, what's the social value of the nuisance? Is the activity that's being engaged in something that's worthwhile to society, something that people value, something that helps society at large? If so, the court is much less likely to find a nuisance. Next, what's the type of interference? Odor, dust, smoke, and sound are typical types of interference. Is it the sort of thing that people such as the plaintiff can be expected to simply put up with and really shouldn't be heard to complain much about? Next, what's the frequency of the intrusion by the nuisance? Is it something that's happening every day or on an ongoing basis, or is it something that only happens once in a while, or perhaps once a week or twice a week? If it's not very often, the court is less and less likely to find a nuisance. Is the nuisance being operated negligently or illegally? And there are several aspects to this question. For example, are there technological innovations that could be put in place that would minimize or eliminate the nuisance? For example, scrubbers and smokestacks or other technical devices that would reduce or eliminate the effluent that the nuisance is producing. Similarly, we could ask whether the nuisance is operating illegally. For example, is the nuisance violating the local zoning ordinance? Some courts would even go so far as to say if it's illegal under the zoning ordinance, it must be a nuisance almost per se. And on the other hand, if it's legal under the zoning ordinance, how could it possibly be a nuisance? Next, who got there first? If the nuisance was already operating when the plaintiff moved there, so that we could say the plaintiff moved to the nuisance, Many courts would go so far as to say that can't possibly be a nuisance to the plaintiff. The plaintiff moved to the nuisance. The plaintiff knew what the plaintiff was getting into, and therefore cannot possibly convince the court that it's a nuisance. On the other hand, if the plaintiff moved there and then the nuisance started up, there's a much higher degree of probability that the court will find a nuisance. Finally, what's the severity of the impact of the nuisance on the plaintiff's enjoyment of life, health, and property? Is this merely a minor inconvenience to the plaintiff, or is it something that is basically ruining the plaintiff's life, destroying the plaintiff's enjoyment? Now, when we look at all of those factors on the previous slide, bear in mind that no one factor is dispositive. The courts will examine potentially all of them. Also bear in mind that some courts will say, if the plaintiff came to the alleged nuisance, the nuisance was already there when the plaintiff moved there, some courts will say the plaintiff is simply disqualified from a finding of nuisance. Also, some courts will say that if the alleged nuisance complies with the local zoning ordinance, it's very unlikely that the court will find a nuisance. Courts often say that in nuisance cases they have to balance the equities between the plaintiff and the defendant, particularly if an injunction is being sought. On the plaintiff's side, for example, they have to look at the hardship on the plaintiffs if no injunction is being issued. What's the impact of the nuisance on the plaintiffs? Is it very severe? Are their lives being made miserable by the nuisance? Is the value of their property largely being ruined? On the defendant's side, they have to look at the hardship on the defendants if an injunction is issued. Will their property's value be greatly reduced? Will its usefulness be destroyed or impaired? Now that sounds perfectly plausible, but in reality, it's questionable whether these things can actually be balanced. In a way, they're like apples and oranges. And the reason is that the hardship on the plaintiffs is often personal. It deals with their actual lives. On the other hand, the hardship on the defendants is largely economic in most cases. It can be measured in dollars and cents and really isn't a personal matter at all. And so balancing the hardships is usually quite an illusory process. Now, every nuisance case is unique. There's no such thing as a typical nuisance case. But I'm going to tell you about a couple of famous and important nuisance cases to give you a feel for the way courts handle nuisance issues. The first case is Bove versus Donner-Hanna Coke Company, decided by the New York Court of Appeals back in 1931. Donner-Hanna was a Coke company, and what that meant is that it was in the business of turning coal into Coke. The way that works is this. Coke ovens, such as the one you see in the tiny photograph there on the screen, were filled with coal, and then the coal was baked for several days at a high temperature. Then the coal was quenched with water, and the coal, which had been turned into coke, was discharged horizontally into railroad cars. The coke was sent to blast furnaces and was used as a fuel for smelting iron ore. It was a very desirable fuel. It worked very well in the iron process, but it produced a fine, gritty substance, which was called coke breeze, and breeze was a very appropriate term because air currents would carry it away from the plant, in this case just immediately across the street to a house where Mr. and Mrs. Bove lived. And so everything on the outside of their house, windowsills, thresholds, windows themselves, the doors, would be covered with this fine, black, gritty substance from the coke making process. They claimed that that was a nuisance. In fact, if they opened their windows or doors, it would get inside their house as well. So they brought a nuisance suit against the Donner-Hanna Coke Company. The court began its analysis by talking about one of the issues that we've previously discussed, namely who arrived first, the Boves, who were the plaintiffs in the case, or Donner-Hanna, which was operating the alleged nuisance. Well, the answer was a little more complex than we've previously discussed. The plaintiffs, the Boves, had literally bought their house several years before Donner-Hanna opened its coke plant. However, when the Boves bought their house, there were already a number of other coke plants in the Buffalo area and many, many other industrial facilities. So the Boves knew full well that they were buying a house in a heavily industrialized area. That was good enough for the court. Second, the court asked what uses the area was naturally best suited for. And to the court, that was an easy question. It was best suited for industrial facilities. It was located where Lake Erie and Lake Ontario come together, so it provided excellent water transportation resources for industrial plants. In addition, it was close to the iron and steel making plants that would use the coke produced by coke plants. It was also close to coal mines, which would provide the coal that was used in the coke making operations. So it was really a perfect place for coke plants. Then the court went through a number of the other factors that we've already talked about. How was the area presently zoned? Well, of course, it was zoned industrial, and therefore the Donner-Hanna plant was operating perfectly legally, and the Boves were in a residence in an industrial zone. Nothing wrong with that, but they must have realized that they were in a bit of a precarious situation. How severe was the harm? Well, the court tended to minimize that. They said, okay, there are some black, gritty particles falling on their house. Doesn't make it impossible for them to live there. It's just an inconvenience to them. What's the social value of the alleged nuisance? Well, you can't operate an iron or steel plant without having coke to fire the furnaces, and therefore it's extremely valuable to have coke plants in operation. The court didn't mention this, but the case comes to the court in 1931. The Great Depression has been in operation for a couple of years. This is one of the few plants that is still fully employing a number of people, probably a couple of thousand employees, and the court must have seen that as incredibly valuable in social terms and almost inconceivable that the court is going to be willing to shut down an ongoing factory in these conditions. Is the nuisance operating negligently? No, the court says there really isn't any technical innovation that we can demand that Donner-Hanna put into effect that will reduce the pollution it causes. It's not operating illegally. It's not operating negligently. There really isn't anything we can do to minimize the pollution. Could the harm be mitigated without closing down the nuisance? We can't see any way that it can be. The question of how costly mitigation would be really doesn't come up because there isn't any mitigation. I think a fair overall evaluation of the case is that the court tends to minimize the factors that favor finding a nuisance. The court tends to emphasize the factors that disfavor finding a nuisance. And of course, the bottom line is that the court finds no nuisance and allows the plant to continue in operation. The threat of closing down a plant and putting several thousand people out of work is just more than the court can contemplate. The second case I want to tell you about is Spur Industries versus Webb Development Company, decided by the Arizona Supreme Court in 1972. Spur Industries operated cattle feedlots, and Webb was the developer of the famous Sun City development for retirees in the Arizona sunshine. The history of the conflict between these two parties is extremely interesting. Spur began its cattle feeding operations here about 20 miles west of downtown Phoenix in 1956. And at that time, the area was extremely well suited for cattle feeding operation. Many other cattle feedlots were in operation in the same area. Webb began planning and building Sun City in 1959. The first Del Webb units were sold about 2.5 miles north of Spur Enterprises' cattle feedlot in 1960. Both of the operations were successful and they began to grow, and they were growing toward one another. By 1967, they were separated by only 500 feet. You can imagine the consequence of that. Spur had 30,000 head of cattle by that time, and each one of them was producing between 35 and 40 pounds of manure every day. Del Webb's Sun City buyers complained about the flies and the odor, and it became very hard for Del Webb to sell those houses in Sun City. So Del Webb brought a nuisance suit against Spur Enterprises. When the case reached the Arizona Supreme Court, the court held that to the residents of Sun City, Spur's feedlot was both a public and a private nuisance, and the court was obviously concerned about the health implications of the flies and the odor generated by the feedlot. Sun City's developer was entitled, the court said, to an injunction, forcing Spur to either move the feedlot or to close it down. However, Sun City came to the nuisance. Spur Enterprises was there first. Now, as we've said before, some courts treat that as a disqualification of the plaintiff's suit. They would say that if the nuisance was there first, the plaintiff simply could not get an injunction. But the Arizona Supreme Court did not take that view. Instead, they created a much more flexible and innovative remedy. They said, well, that fact will not deny the plaintiffs an injunction. However, because Del Webb came to the nuisance, Del Webb must pay the cost of shutting down or relocating the feedlot, a very imaginative approach to the remedy of an injunction. The Spur case illustrates that nuisance remedies are flexible and that courts have a lot of discretion in deciding what remedies to issue when a nuisance case comes before them. For example, a court might give a partial injunction, not everything that the plaintiff wanted, but an injunction that's carefully tailored to the facts. A court might order implementation of technical changes, such as installing scrubbers or screens, so as to reduce the amount of pollution that the defendant is discharging. A court might order an injunction, but with the cost of moving paid for by the plaintiff, such as in the Spur case. A court might order damages paid to the plaintiff. The defendant would then get to continue the nuisance-like activity, but would have to pay the plaintiff money. Is this like giving the defendant a power of eminent domain? Well, perhaps so, but there may be other plaintiffs who haven't yet received money and who might still be in a position to bring a nuisance action in the future. So the defendant still has to worry about getting everybody paid off, whereas in an eminent domain action, they'd only have to pay once. It's a tricky position to put the defendant in. Nuisance law has become considerably more important since the decision of the U.S. Supreme Court in 1992 in Lucas versus South Carolina Coastal Commission. In that case, the court decided that a government regulation can't be considered a taking, which would require the government to compensate the landowner, if the activity that the landowner was engaged in would have been considered a common law nuisance. So often the government, if it's being charged with compensation, will try to prove that it doesn't owe any compensation because the activity that it's regulating would have been a common law nuisance. So it becomes increasingly important to determine what a common law nuisance amounts to. It can be considered quite an important determination. We mentioned at the beginning of this video that there are two kinds of nuisances, public nuisances and private nuisances. The basic definition of the two is the same, but public nuisances affect broad groups of people or society at large, whereas private nuisances affect only one landowner or a small group. Public nuisances, for example, would be pollution of public waterways, harm to public parks, public roads, or other public facilities. Enforcement of a public nuisance normally has to be by a public officer, such as the Attorney General, or a government agency which is charged with supervision of that particular type of public land or public facility. However, a private party can sue for enforcement of a public nuisance if they are directly and uniquely harmed. Public nuisances these days are often dealt with by environmental statutes. For example, statutes dealing with air quality, water quality, coastal erosion, or wetlands preservation. Usually we have statutes that deal with those and specific agencies that are charged with preserving and caring for them. To summarize what we've learned about nuisance cases are not very predictable. They depend on what a court views as reasonable. There are many factors for a court to weigh, and courts have a lot of discretion in weighing them and in determining what remedies to grant. What this means is that if you're given a nuisance case on an examination, there usually isn't a single correct answer. Instead, what you need to do is to identify the relevant factors and consider what a court might most probably consider to be reasonable. That concludes ProfDale's property video number 51 on the doctrine of nuisance. If you have questions or comments, email profdale01@gmail.com. Thanks for watching.